Okay, we're going to go ahead and get started. Thanks to everyone who's joining us here. And we'll also, of course, welcome those that are a little tardy getting here. There's also, I know, a lot of people on live streaming at various platforms that are joining us. So thank you. And let's start right out with a just an update on Meta and where we are. As all of you know, Meta has become very aggressive in stopping any discussions on their platforms for Kratom. And they have various justifications for it, but it boils down to their adhering to the FDA's belief that kratom is an opioid, therefore dangerous, and that they are considering it to be an unapproved drug and an illicit drug for all of that matters. So we've been attempting to work with Meta in order to have a discussion about how their decisions actually impair the First Amendment rights of advocates to be able to go in and while they may disagree with us, it is a invaluable resource to be able to go on to Facebook, which many local governments use as a way of distributing their agendas, for us to be able to discover that and to be able to properly interact with it, and also to just have general discussions about policy disagreements. And the Met has put us off a couple of times, but now we have a newly rescheduled meeting that will come up on Thursday, and we'll be able to report back, and hopefully we'll persuade them that they cannot rely or should not rely upon the FDA's disinformation campaign with respect to kratom. So at least we've got them engaged in a discussion. We have our advocates on Capitol Hill who have also reached out and told Meta's lobbyists there that they want a resolution to this issue and how unfair it is. So we'll, as I say, give you a good update. If anybody during the course of this discussion has any questions, you can just put them into the Q&A and we'll be able to answer them. I'm glad to do so. So that's the first item I wanted to discuss. The second, and I know it's one that everybody's interested in, is what impact that the incoming Trump administration will have on kratom policy. And it's a very interesting and complex issue, made complex in many respects by a fairly significant disruptive decision that's been made by the incoming Trump administration about the way that federal employees engage in their work. After COVID, the government stayed in essentially a remote status, and President Trump has ordered everybody back to work. And the interesting thing about that is that many people went to a situation where they sold their homes that were close to their workstation, whether it's primarily in Washington, D.C., but in other areas around the country as well. And they bought less expensive homes and probably in a better quality of life situation. And now they're being ordered back to work. And so for some people, it's not going to work. And that'll be interesting to see how that plays out. There are people who are interested in taking the buyout offer that the Trump administration has offered for federal employees. Of course, from the Trump administration's perspective, they're trying to reduce the number of federal employees, but it's a very crude instrument because you don't know what segments or pockets of federal employees are actually going to leave and at what levels that there are. And so you could have what essentially is a brain drain in very critical areas that might cripple some of the functions of government. And so that is yet to be determined. And then there's a third level of people that just don't agree with the Trump administration. I think that that was a large part of the decision by some of the senior staff at the Food and Drug Administration who have been anti-kratom. And that includes our nemesis, who served in a senior position at the FDA, who decided to retire as he faced going into work for under the Trump administration and for Mr. Kennedy, who appears now to be on track for being nominated pretty much the way that the Secretary of Defense got in. It might be a tie vote with the vice president casting his vote, but Mr. Kennedy got a substantial boost in his chances for nomination being secured when Senator Cassidy said that he would vote for him. So it's a very interesting dynamic that's playing out right now. I know that there's also a big push within the Trump administration to find ways that they can effectively reduce costs. And one of the areas that they're looking at HHS is how can they reduce the cost of substance abuse treatments, which currently are reimbursed only for a trilogy of prescription drugs that are approved by the FDA for the purpose of weaning off of some of the substance abuses that people suffer from, includes things like Suboxone and other drugs. And now, because of the squeeze for money, there's some consideration at CMS and at SAMHSA where they would look at Kratom, which has been documented by the National Institute on Drug Abuse as a potential harm reduction therapy to help people wean off of opioids. And they're actually looking at it, which of course would then trigger a lot of discussion within the government about what the Kratom universal and consistent Kratom policy should be. And I think that's going to be very important as we go forward. And then finally, I would say that some of the people that are going into these positions of influence are going to have a different view of Kratom, led largely by the conclusions that Dr. Giroir, who was the Assistant Secretary for Health in the first term of the Trump administration, and his evaluation of the FDA's scientific dossier on Kratom, which he characterized as being embarrassingly poor evidence and data and a failure to consider the overall public health. And so this incoming Trump administration remains a lot that remains to be seen about how things are going to play out, but it certainly is more encouraging than what we've seen for the past several years. And I think we have reason to be at least somewhat optimistic that there'll be a better view. We're also told that the incoming NIH director has a very positive view of Kratom, as does the existing director of the National Institute on Drug Abuse. So this may all be coming into a perfect circle as we go forward here in understanding this. And we're hopeful that if Mr. Kennedy gets confirmed, that he will then pursue a very hopefully a pro-Kratom agenda, which is consistent with his view of the overreaching overregulation by the FDA in a number of these areas. So we'll continue to keep you posted on that as well. Another issue that I know many people are very concerned about relates to the fact that that the Indonesian government continues to sort out their issue with their new regulations, and there is a lot of information that is emanating from Indonesia that is flat out inaccurate. One of those rumors is that the the AKA was a big advocate for these new regulations. That is simply categorically untrue. I sat in Indonesia in multiple meetings in August where I argued strongly against the pernicious impacts that these regulations would have. And I argued that their fundamental belief that by implementing these regulations, which in part, not completely, but in part, would have established a more secure supply chain for Kratom raw materials and allow for some testing, the Pollyannish view of the authors of that regulation was that in doing so, that the FDA would lift the import alert. They fundamentally misunderstood that the FDA uses the import alert only as a tool in order to achieve its objective, which is to ban Kratom. And they do it with a shadow ban by claiming that all Kratom raw materials are adulterated, therefore not eligible for entry into the United States. And that's just a way to try to ban Kratom that they can't achieve by following the appropriate procedure for the Controlled Substances Act criteria, which of course they can't justify on the science. So complicated, but all of the information that you're hearing from about the AK's position on the Kratom regulations in Indonesia is categorically false. And those people that are spreading that kind of nonsense on some of the chat boards simply have to face reality that we have always been an advocate for two things. One is there ought to be a fair commodity-based trading practice and foundation for Kratom raw materials. We want them to come into the United States. We want them to be safe when they are, and we want them to be fully compliant for their wholesomeness and quality as they do so. And the people that are now pointing the finger of blame about the catastrophic rollout of these regulations, which has shut down Kratom shipments for now 4 months, simply have to understand that now they're just looking for someone to blame. It's not the reality of the situation. Very unfortunate thing. It's hopefully going to break loose. The farmers have finally risen up, And 2 days ago, they got a commitment from the Ministry of Trade under the new government there. They just did a transition in November, has now said that they have to start shipping kratom. So maybe that log jam will be broken in a couple of weeks, but it's not going to be easy. And the shippers over there are trying to avoid responsibility to make sure that their products are safe and wholesome as required by the FDA and by vendors that are accepting raw material and paying for them. So a lot of unanswered things that are happening there as we go forward, but we'll continue, as I say, to work on that. Um, Next issue, just to give you a briefing on, the UN Commission on Narcotic Drugs is going to convene its annual session in Vienna in March. And it's our understanding that there is a push by some member states of the 140 some odd members, treaty members of that organization, of which the United States is a member. There's an effort to try to refer kratom for international scheduling again. And of course, that would go to the Expert Committee on Drug Dependence over at the World Health Organization. And I don't think it's going to be a big deal in terms of the US's participation in funding the WHO. This is a group of 12 independent scientists from around the world who annually look at every substance that's referred for consideration from the UN Commission on Narcotic Drugs. We are planning on having what's called a side event at that particular meeting. And if they accept it, we're waiting, we expected and hope to get it already. It's a very competitive process, but we haven't confirmed it. But if we do get a side event, we're going to have the leading scientists in the world that will be there in order to address any issues and any questions that the UN Commission member states have about kratom and its current scientific safety profile that can be evaluated. So we've made an investment in that, and we intend to do it, and we will be present. I should also mention that a collateral part of this discussion is driven by the decision of the Swedish government to recommend from their health department that Sweden now amplify its current ban on kratom by saying that no one can sell it. Currently, there were workarounds within the Swedish government where they could work on that and actually ban it. Now they're going to say you can't even sell it no matter what, as long as it is available currently. You can't do that anymore. So that's something that's very concerning to us. We're reaching out to the Swedish government, but frankly, we haven't been successful yet. We're doing our best, but when we're there in Vienna, we hope to have discussions with the Swedish officials on this issue. So that's that. The next issue I wanted to talk about is 7-hydroxymetrogenine. This is becoming probably the most controversial issue in the kratom space, and there's as much as it's controversial, there's a lot of misinformation that's going around. We are being accused at the American Kratom Association of being soft on 7-OH products. We are not. I would encourage everyone to look at the consumer advisory that we issued on the 21st of January, I think it was, where we not only identified our position, which is that we are opposed to kratom products that are above the level of 2%. Now we know that 7-hydroxymetrogenine cannot exist in a natural form at above 2%, and it would have to be synthesized. And we completely oppose any of those kinds of products that are being on the market. But we can't wave a magic wand and ban them because they are entitled to a market position under the Federal Food, Drug, and Cosmetic Act and the Dietary Supplement Health and Education Act, which says that if you go to market and you have a reasonable basis prior to market entry for the safety of your product under the conditions of use, you can do so. And our argument has been two things. One, every 7-OH product ought to be subjected to that standard and held to it. In addition to all other kratom products that are not kratom alone, they should be held to the same standard prior to market introduction. We know 7-OH products are in the market. And so the second issue would be whether the kratom products are safe. I'm sorry, the 7-OH products are safe under the conditions of use. Our argument and the agreement that we signed with one of the 7-OH manufacturers was that they would not market a kratom product that they claim is kratom at above the 2% level as kratom. If it's 7-hydroxymetrogenine, call it that. If they can meet the safety standard required under the federal statute, then prove it. If they can show that under certain conditions of use, which means the level at which is going to be set at 2%, then they need to prove it. And they have to show that because we know that the concentrations of 7-hydroxymetriogenine are much higher in these highly synthesized products. And we simply will not tolerate that level. But the reason that we're getting attacked on this is for, I would argue, self-serving reasons by the Global Kratom Coalition, which has chosen to make this one of the battle royales. And for example, they make a claim that the AK is soft on 7-OH products because one of our major contributors manufactures a 7-OH product and is one of the leading manufacturers of 7-OH. We have investigated that claim. We know the specifics of it, and it is not true. And the information that is being spread by the Global Kratom Coalition should be discarded because it has no credible basis for being actionable. We do strongly encourage any kratom manufacturer who participates in our good manufacturing program to not sell 7-OH products. And we got an alert on one today that we're going to be talking to them about, because while the GMP program only covers the processes by which they make their products so that they mirror to meet or exceed the federal standards for good manufacturing practices, we do not endorse products. Nor do we say that those products are good or bad. We simply say that the standards that are required for GMP of the products that are produced has been met. And that, of course, is a quality standard and a safety standard that's important. But it is clear that we now need to take the next step. And what we have committed to do, that for every 7-OH product that we can identify in the marketplace that is marketing it as a kratom product, that we're referring them to the Food and Drug Administration for action and to the Federal Trade Commission, because that becomes a violation of the consumer statutes for mislabeling and misleading consumers. We are resolute in this because we choose to follow the law. And because we do not wave our wand and say we can demonize some particular product, but yet the same problem exists for some product formulations on the kratom side, we will not be hypocrites. We will have a consistent, principled stand on these products. And of course, that raises the issue, which is the primary product being advocated for by the founder of the GKC in Botanic Tonics in a kava kratom product. There's another issue from the AKA's perspective that is being mischaracterized by the GKC. We are not against kava kratom products any more than we're against 7-OH products that meet the compliance standard if they do. And that's the if that's big. So if the kava kratom formulations are able to, prior to market entry, establish a level of safety under the conditions of use, then make them prove it. And that's all we are saying. But we're not going to be violating our own principles in order to say it's okay for this product formulation because these people want it, and yet over here they're saying that the 7-OH products cannot be marketed. We don't think either should be marketed if they cannot meet the very strict standard for proving the safety as they're going forward. So in an abundance of trying to gather information, the American Kratom Association invited a group of scientists and advocates for each of these products to a symposia that we held 2 weeks ago in Miami, Florida. We allowed the presentations by these product manufacturers, and then we had an evaluation made by the scientists. And those symposia speak for themselves. There were serious concerns raised about 7-OH. From our perspective, it became clear that there was not the requisite safety data that was required for market entry prior to doing so. It was the horses out of the barn theory that since it's there and because it's being used by lots of consumers, therefore it must be safe because we're not seeing any significant adverse event data, despite there being millions of servings of 7-OH products that have been sold, and we're not seeing it. Well, I hope all of you will look at the op-ed that I did for the Natural Insider magazine because it illustrates and identifies the problem. In the FDA's FAIRS database, that's the FDA Adverse Event Reporting System, we don't see very high numbers of 7-hydroxymetriogenine adverse events reported. In fact, there's only 2 in the last 2 years, but there are hundreds of so-called kratom adverse events. And the reason is that no one at the testing level of the people that are making these reports are looking at whether this is a kratom pure leaf product, a kratom extract, a kratom mixed product with kratom and kava, or kratom and name the product, or whether it is an adulterated, highly spiked kratom product, or it's kratom and 7-hydroxymetrogenine, or 7-hydroxymetrogenine as the predominant component of the product. Nobody is looking at that, and not the FDA. So it is in effect simply a very bad database. It's disinformation and doesn't and should not have any credibility in assessing an adverse event or a death that is supposedly related to kratom. This is an important point to be made because we can't allow the FDA to just put up this rumor mill and not be accountable to the quality standards that are required. And we certainly can't let a manufacturer say, because there isn't any serious adverse event that's specifically targeted to and identified as 7-hydroxymetrogenine, when in fact we're not testing for it, is the problem. If, and it's a big if those products, and it includes kava kratom products, the same issue, because they're saying that in their market experience, they're not seeing significant adverse events, but the scientists have significant concerns nonetheless. We need to reconcile those things, and so science should prevail. The horses out of the barn theory is not very persuasive, and it certainly it is not a legitimate basis to argue that you can be there, having violated the standard that requires all of that safety data to be in place prior to market entry. We agree that reasonable people can disagree on these issues, and we certainly are. That's why we convene these panels to try to examine those things. But we are not what our critics are saying, that we're somehow favoring one product over another, because we do it on a principled stand that we're trying to work on, and we will continue to do so. Uh, the Global Kratom Coalition has obviously made this a very personal battle, trying to make it a personality clash between Mr. Ross and me. It simply isn't true. It may be true at his end. He obviously is acting out. He has filed another lawsuit now in the state of Virginia against me personally and the AKA, alleging misappropriation of funds, which we will argue in the court and prove is simply not true. These are groundless accusations, but they're really designed to, in our opinion, to get out there in order to discredit the American Kratom Association, while he, through the Global Kratom Coalition, which he funds and runs, is out there rewriting all of the KCPA laws. He's going into every KCPA state and trying to create a new regulatory paradigm which advantages his product and disadvantages product formulations that are otherwise safe that consumers are using. And to us, that's just simply an unfair marketing tactic that should not be allowed to continue. So our position is that you cannot market a 7-hydroxymetrogenine product if you market it as kratom, if it's above that 2% level. We know that that's a synthesized product. That if you are going to manufacture and market a 7-hydroxymetrogenine product, you cannot legitimately, or should not legitimately, claim this is better than kratom. The only way it's better than kratom is that it has a higher addiction liability. It binds directly to the mu-opioid receptors. It is a full agonist, and it has all of the opioid-like characteristics that lead to dangerous addictions and potential fatalities. So we're not in on that deal. Equally true for the kava kratom and other combination products that are mixed together. Prove it. And as long as you can prove it, then we're fine with it. But we can't say one's good and one's bad without that standard applying across the board to everyone. And that's, of course, the goal that we have. So we will continue to fight based on that principle, with the recognition that there are consumers who really want to know the truth of it. And we hope that it comes out quickly, and that the states that are currently evaluating the safety profile of those products will come to swift conclusions and inform the public about what is allowable and what is not. All important stuff. Let's go to the state updates. And I think that, and I hope I don't miss any of these, but it's possible I will. And so I want everyone to hold me accountable on this in your questions and answers if I miss something. First, in the state of California, the GKC promoted a bill in the last session that we thought was overregulation, designed to be anti-competitive, and it would have reduced the number of companies that are allowed to be in the market space, because it simply was too expensive, and it would have created a registration fee that was so onerous that it would have eliminated a lot of the competition for the products that are being, frankly, advocated for by the GKC. and we thought it was unfair. It would have reduced the availability of products to consumers. It would have significantly increased the prices on those products, and it would reduce the novel formulations that Kratom manufacturers, and it happens in every industry, that they would do. So we opposed it, and we did it on principle. And of course, that has earned us the ire of the GKC, but we'll live with that because we believe in it. We're seeing a similar thing happen in Colorado. I'm here in Denver today, having participated in a hearing in Colorado where the Global Kratom Coalition's bill was heard. It is interesting because we were not advised or allowed to participate in the discussion about what the actual regulatory framework would be for Colorado. And it frankly mirrors in many respects, not quite as bad, but very close to what California did. It empowers a mini FDA bureaucracy to be built in the Colorado government. The KCPAs were never designed to do that. The Kratom Consumer Protection Acts were designed to require a manufacturer to be able to determine that their product formulation met or exceeded the standards for the state, which dealt with GMPs, which dealt with kratom with product formulations that were safe, that dealt with mixed products and how they could get to the market, and with 7-OH. And it also allowed for testing procedures and put the burden on the manufacturers on all of those things so that when they submitted their registration for the products, they proved that they were compliant with certificates of analysis and written declarations that they were not spiking their product with dangerous substances and that they met the standards, and then labeling, depending on what the state determined to be, that they complied with the labeling requirements, and then assessed an age limit. That's what our KCPAs do. They were not designed to bring in a whole new bureaucracy. And if you just read the definitions in the Colorado bill, and they mirror what was in the California bill, you will see how absurdly detailed they are. And you cannot even blame the regulatory agency for saying, yes, we have to add armies of new consultants. We have to hire experts to determine what is a synthesized product. And you should read it. You should read it, how detailed it gets. And legislators have no idea. They've never heard these terms before, but the regulators have. And so that's why you see these very regulatory intensive fiscal notes, which assess a very high cost to actually regulating these products when it really ought to be the burden on the manufacturer. I told the sponsor of the Colorado Kratom bill, which we already have a Kratom Consumer Protection Act in Colorado, subject to enhancing some of the regulatory functions. One of the things it should do is limit 7-OH products, which they stripped out at the last minute when we passed it. But the rest of it can be contoured into a very effective bill without that big fiscal note that would disadvantage Colorado manufacturers. The small to mid-sized one will favor only the large manufacturers. And as an example, they say that that in order to register your product, you have to pay a per product registration fee. Now, in order to pay that fee, you have to cover what the fiscal note, which means the total amount of money that the agency says that they have to collect in order to meet the standards in the regulatory or the statutory language. Well, in this case, it's a very tough, very intensive regulatory scheme. So they have to raise about $600,000. To do that, they have to charge based on the estimates of the fiscal note, the various kinds of factors they evaluate, and they literally said, based on input from the Global Kratom Coalition, that there would be 2,600 products registered. In the state of Utah's contrast, there are just about 600 products, 600 versus 2,600, that there are going to be about 90 registrants. In Utah, there's 55. So you can see the gap. And when you do the math, it's very easy to see that instead of the $206, which they claim it's going to charge per product, it ratchets up to well over $1,000 or $1,200 per product. And think about this. Which companies have just a couple of SKUs? And which companies have multiple, if not over 100 SKUs? And who gets disadvantaged in that cost allocation? Pretty clear of where we are. And I think that when I concluded the testimony and then had the occasion to meet with some of the senators, I think senators, that message resonated. That legislation should not be about protecting or creating winners and losers in the marketplace. It should be, and it shouldn't protect big companies. It should protect consumers. And you don't abuse legislation by playing these silly games that are designed to eliminate competition. So the Colorado situation is unique in that it did pass from the committee with the promise of amendments, but it still has a very high fiscal note. And we hope that the amendments will reduce the burden on the state, shift the responsibility to the manufacturers, and then not have these high fiscal notes that create barriers and eliminate competition along the way. So we're going to continue to work on this. We probably got a month between now and the Appropriations Committee to resolve these issues, but it's very tough in Colorado this year to have any fiscal note bill that is going to require an outlay by the taxpayers. And they also have a very unique constitutional provision that limits the amount of money that can be collected before it has to be refunded back to taxpayers. So this is a complex situation that wasn't well thought out by the framers of the Colorado bill. But I can tell you some good news on the horizon. In North Dakota, where we were fighting, obviously to get a good KCPA, stop a ban, we had the occasion for representatives from the Viva Zen group, which has a trade group, and the Global Kratom Coalition. And we sat down and discussed how we could create the framework for a KCPA that we could all agree on, but it would be modeled after the Utah bill with some modifications of lessons learned. But certainly we know what the framework is, and it's not this intensive regulatory scheme. But the GKC refused to let that be presented to Colorado. When I told the Senate sponsor that today, he obviously was taken aback a little bit because he wants to know what exactly that is. We are hoping to finalize that agreement in a discussion in Florida on Thursday. And I hope we can report that we've been all sat down together and come to a reasonable accommodation going forward. We'll continue to work on that. We have asked a group of industry members to give us advice who attended the Miami meeting that I referenced earlier. And I hope that they'll come up with some ideas about how we can improve the Kratom Consumer Protection Act as we go forward, because our goal here is to have a strong industry that produces quality products that are well labeled and that are effective for consumers so that they don't get into a problem with safety risks that are unnecessary and that they are pure and safe products. So that's the report on Colorado and some of the ancillary issues associated with it. In the state of Arkansas, this is currently a banned state. We are going to have the KCPA introduced, and we did get a due pass recommendation out of the interim committee that was held prior to the legislative session. We think we're doing great there. We obviously will have a challenge at the end of the legislative process where we remove the ban and replace it with the KCPA, where we have a very hostile Department of Health, and we have to see where the governor sits on this. We could end up in the same boat that we were in Rhode Island here last year, which I'll report on in just a few minutes on Rhode Island. So Arkansas looks good. North Dakota, we have the KCPA moving forward, and we defeated the ban, and now we're on to the KCPA. In South Dakota, a similar situation where we have a cobbled together KCPA where the legislative assistant to the sponsor wouldn't take our bill, but wanted instead to be independent. And so she went out and cobbled together from all 13 bills a regulatory framework, which is a little odd, but still we can live with. And this is part of the legislative process to figure out how we can compromise and get something. As I sat in the hearing in South Dakota, it sounded like a ban hearing, and people that were for this, cobbled together KCPA, which we can live with, were all anti-Kratom. And I was the lone wolf in testifying there in Pierre, South Dakota. But the bill passed through the committee unanimously, went to the floor of the House and passed 66-0, I think it was, or I can't remember exactly, but it was overwhelming. And so I think we're maybe 77-15, I think. So I think we're doing great. I'm sorry, I'm wrong. In South Dakota, it passed unanimously. It was North Dakota where we got through with a pretty good, healthy vote. So we're working hard on those states. In Nebraska, I was there last week, and we think amendments have to be made. This again is a GKC bill, and we've persuaded the sponsor in working with the Global Kratom Coalition. We came to a good outcome, and I think that we're going to be fine in Nebraska. Not a perfect bill, but one that we can live with as we go forward, and it'll help us. In the state of Indiana, there was a bill proposed that would have replaced the ban that's in Indiana with another one of these hyper-intensive regulatory bills. We're working closely with the sponsor there. We think that we'll be able to replace it with what we hope will be a modified KCPA that is endorsed by the Viva Zen Group and by the Botanic Tonic Groups, GKC, and the AKA. And I hope that we get to that agreement because that would be great to turn over Indiana. We did get our KCPA passed in Indiana 2 years ago, but we got stopped on the Senate side, and that remains a challenge. But maybe there's an opportunity here to move forward. In the state of Rhode Island, all of you know that we passed the KCPA through the legislature and then the governor vetoed it. I just finished a round of negotiations yesterday with the Rhode Island governor's staff, and this is going to be a painful process, but I think we're going to get to a position where the governor will sign a bill. It's not going to be a perfect bill, but we will continue to work hard to protect consumers in this. They want some limitations on it that are going to be a little tougher in terms of consumer access, but we're probably going to have to live with them as we go forward. In a couple of other those northeastern states, we see in New York and New Jersey and Pennsylvania, lots of issues that we've got bills are being filed in New Jersey. We got CJ's ban bill. We're working hard in each of those states with a good lobbying team, and I think we're going to be able to at least get past the ban bills because they're certainly not justified and get to a reasonable discussion about how we regulate it going forward. And hopefully we'll have good news from one or more of those states as we go forward. We've been working hard in New Jersey, New York, and Pennsylvania for more than 4 years. So hopefully we can break the logjam. In North Carolina, this is a toss-up. We got close last year, ran into one senator who claimed that a good friend of his son died of kratom. This happens, and we had to educate them. We're now ready to embark on a new round of discussions, and hopefully we'll get the bill in North Carolina and in South Carolina. There's a ban bill there, but I think we can overcome that as we go forward. State of Florida is an important market for every kratom consumer because you see that the sales are high there. We are having a dogfight there in order to get a reasonable accommodation, and the players in it are the GKC, obviously we've got the Department of Agriculture there, which wants to restrict our products dramatically. And we've got a state senator who appears to be wanting to do the right thing, and he's working hard to understand it. And he's trying to referee between all of these factions, but that's something we're working hard on as we go forward. We have a replacement bill in Georgia that we're going to have introduced and pursue because we think that the one defect that Representative Rick Townsend articulated while he was shilling for the trial attorneys was that the problem with the original KCPA that was passed in 2019 in Georgia did not have a regulatory body or agency that was in charge of enforcement. He said it on the record. When his bill passed, it did not have last year, it did not have an enforcement agency. It's because he was listening to the trial attorneys who had one objective, had nothing to do with enforcement, but all about being able to trump it before a judge and a jury that Georgia had essentially a kratom ban, or at least very significant limitations. So we're coming back with an enforcement agency and the way that we can actually have it help. And we hope that Representative Townsend will side with us and work with us in order to get that done. So we're going to continue to work there in Georgia as well. I can tell you that all of you know that we're in a terrible battle in Mississippi, and this has been going on for more than 5 years. And you've got the sheriff's associations and the county people who are following the FDA's disinformation about kratom, and they've demonized it and they've made it hard. Today, the committee passed out a restriction on kratom sales to make it a Schedule III drug. And that, of course, is a death sentence for people that want to be able to have access to kratom. So we're working hard to see if we can defeat that bill and hopefully keep the status quo, if not get some version of a KCPA through. We face a similar situation with law enforcement being anti-kratom in Louisiana, but they're just coming out of a bruising fight about intoxicating hemp products, and it's unclear whether in what's called a fiscal session, budget session, whether or not this is the right time. But we're going to watch for any bans that pop up, and we're going to assess whether we have a chance at moving forward in Louisiana. They haven't started their session yet with getting a KCPA through. Kansas just filed a KCPA today, which looks good. Montana's in the same situation. They've got a KCPA. The state of Washington will have a KCPA filed. The Pharmacy Quality Control Commission is proceeding with their rulemaking to ban kratom. We think that the filing of the KCPA in Washington will at least slow that down. And we know that the science will not support a scheduling decision. So we'll continue to fight and work hard on the Washington Pharmacy Quality Control Commission going forward. In Nevada, our KCPA bill with some refinements has been filed. We're watching that closely, and Speaker Yeager, who's been a great champion for Kratom, for freedom of consumers to have access to Kratom, has been a real assist for us there, and we're going to continue to work in Nevada as well. Lots of these states, by the way, as you can tell. In Utah, we're facing a little bit of a problem with the Department of Agriculture. They are now going to form a specialty products division to put more attention on kratom along with other substances. So there's a rumor out there floating that now there's this huge fiscal note on the KCPA, but no, it includes other products, part of this new specialty products division. We'll sort that out for you, but we're working hard to make sure that they have in Utah the maximum authority to protect the marketplace going forward. And we think that they'll be in a good position to do that. In Michigan, we're working with the Department of Health. They have been difficult, if not impossible, to work with. We're going to continue to work hard with them. That's true in Illinois as well. We're going to have our bill filed. There's a problematic bill promoted by the Global Kratom Coalition that we hope will be able to be overwhelmed by the KCPA, which we've been working with for several years there, and we'll continue to do it. Same is true in Ohio. We are working hard to get the KCPA back. We're fighting with the Department of Agriculture, who wants to limit it. And literally in the state of Ohio, the Department of Agriculture's position on kratom is that you cannot sell kratom because of the FDA's determination that it's it's a drug, unapproved drug, and an adulterated dietary ingredient. And they do allow kratom to be sold if it's in a plain wrapper with no labeling on it, because then no one could infer that it's for human consumption. This is insanity. And yet that's what they're credibly saying, and they think is credible to say. So that's helping us in Ohio to wake up some legislators there going forward. In the state of Wisconsin, we're currently evaluating and will plan to file an appeal with the Controlled Substances Board to get them to trigger a rulemaking proceeding to remove kratom, which they've already acknowledged does not meet the 8 factors. And we hope that will stimulate and be the catalyst for the legislature to then regulate kratom. And finally, Hawaii. We have a bill filed there. We're having great discussions over there with the various legislators. We did get a little opposition from the kava groups, where they don't want kava and kratom mixed together, and we thought that was kind of ironic. But they have a lot of kava bars over there, so we're going to continue to work with them, work with the local people along the way. So I don't know if I've missed any states that we're working in, but it's a lot. And I can tell you that we are doing everything that we can. I'm going to turn for the moment to the question and answers, and I'll go through these, and then hopefully we'll capture. If you've noticed something I missed or you want me to talk about, I'm glad to do so. First, Michael asks, is Illinois trying to ban kratom again using an amendment to the existing Kratom Control Act filed today? Absolutely right. I think we'll win that battle on the ban, but we're going to be fighting for the KCPA and certainly have an age limit on whatever comes out of there. I think I answered the status of the situation in Washington State that JJ asked. And we think the KCPA has a decent chance of passing there because we've been working with some key legislators that are influencers there going forward. Anja asked about anything that's going on in Nevada. We have a great bill in Nevada. There is no bill to ban kratom or kava in the state of Nevada that I'm aware of. I can tell you that the kratom is legal for sale. The Board of Pharmacy or the Board of Health in Southern Nevada is on a tear to try to stop kratom sales. We're appealing those decisions because we think the state law covers them. But we know that we've got to fight there in with the health department because they're not following the law. And we're working with retailers there and the various exhibitors at shows that are being shut down or attempted to shut down by the Department of Health. So a mess there, but we're going to continue to work on it. Samantha asked what we can do in Mississippi. This is really unfortunate because we've worked with the firm in Mississippi for a long time, for years, And we were cut off at the AKA from being able to have contact with that legislative group. Um, and very disappointing because they're being paid for by another group. And it is just awful of what's going on there. So we're going to do our best. And this infighting is obviously not a great situation that we're in. So that's where we are. I'm going to try to keep tracking on these. I think I answered the Arkansas situation. We think we're very optimistic. We're optimistic we'll get it passed through the legislature. The question, of course, is the governor. Cody asked if we have, I'm sorry, we just did that one. Melody asked what are the issues with the KCPA bills in Mississippi? This is a very convoluted, difficult process, subject to a lot of negotiation. I don't know the answer, how it's going to come out yet, but we're going to continue to work on that as we go forward. So we'll keep you posted along the way. And Melody asked what the status of the fellow got in the car accident in Indiana, was arrested because Kratom was in his car. Indiana's a tough state because it's banned, and so they're still going through the court process, at least as I understand it. We'll have to see how that plays out, but I think that the courts are, I've been told the courts are going to be much more lenient than what we saw in Alabama or in Arkansas going forward. The territory of Jorge asked, the territory of Puerto Rico passed the KCPA in 2023. I don't think that's true. I'd love to know if it is true, but when I talked to the people down there, it got stymied and they're going to have to refile it. But I would love to have an update on that. If you have it, let me know because that would be great. Lisa asked about Vermont. Vermont has gone through a tremendous number of staff changes within their Department of Health. We have a written confirmation that they're going to remove 7-OH and Kratom from their controlled substances list, but they haven't done so yet in final form. I know that this discussions are going on between the chair of the House Health Committee and the department about how they could jointly work together to delist conditioned on the passage of the KCPA. So we're hopeful that that's going to be done, but it's a work in progress as we go forward. Michelle asked about update in Texas. The KCPA is in force there. There's some issues that are rising in Texas where interference is being played about the 7-OH issue, and it's an inappropriate way to do it, we think, but it puts us at risk, and we're hopeful that cooler heads will prevail on as it goes forward there in Texas. So we'll do what we can along the way. JJ asked, will the AK be contributing to the meeting? I can't remember, JJ, which issue you were talking about. Retype in which meeting you're talking about so that I can answer that. The pending amendments, Mary asked where are the pending amendments in Colorado. The committee did accept 2 amendments. They're not bad amendments, but they don't do what the sponsor thinks they're going to do, in our opinion. But they should be posted up on the language from the Senate committee today that was passed out, and they should be up on their website very, very soon if they're not already. We're going to continue to work with the sponsor there. James asked whether the Washington Pharmacy Quality Commission has the ability to rulemaking on Thursday or March 27th. This is a process that they're going through, and this lawmaking thing takes a long time. But if they made a decision and made a final decision, it could take effect fairly quickly. But I think that they're going to defer to the legislature to see how it's going through. And they were told by their advisor from the Attorney General's office that this was a tough row to hoe for them to make a decision to schedule Kratom. So I'm hoping that they'll consider all of that as they're going forward. So we'll hope, fingers crossed, we're going to be able to get a decent outcome there. Brian Del Rey asked what changes the Florida Department of Agriculture is trying to pursue. I'm going to tell it to you straight. We were negotiating on what the Florida Kratom Consumer Protection Act should be with the Global Kratom Coalition and some other stakeholders, while behind our backs, the Global Kratom Coalition was going and talking to the Florida Department of Agriculture and empowering them to use a regulatory framework that was close to what they were advocating for in in California. And it has created a mess beyond imagination. But despite that, the Department of Agriculture themselves actually are proposing that there be a limit of 5 milligrams on any Kratom product. That's crazy. And yet that's what they're doing. We've given them all of the information from even the FDA's own dose finding study, showing that you got to 12 grams of material in a 5 minute period, which is 12,000 milligrams. And we've shown them that market experience data where products can be between 130 and 210 milligrams in a dose and no adverse effects. And then the amount that could be in a container of products. This is a difficult issue because the Florida Department of Agriculture is not a great fan of Kratom. In fact, they would prefer to have it banned, but that's a battle that we have to continue to fight. And it is a significant issue for us at the AK, and we're going to continue to fight as best we can. Samantha asked, who is the group that banned the AK from the Mississippi state legislation? It was another competing group that we've worked with cooperatively over the past couple of years, and suddenly they pulled the plug on our involvement. And I think I'll leave it at that. It was suffice to say that hopefully our meeting on Thursday will open the floodgates. I can tell you that they rang the alarm bell 2 days ago, and we jumped to the need for advocates to weigh in, but we didn't have the information prior to that and weren't a part of the negotiations for it. So I think that that's really sad that we get into this kind of infighting, all to just kind of be who's going to be the top dog in this. And some people have far different agendas than we do along the way. And I'm not suggesting that I'm perfect or that the AK is perfect. Goodness knows that we have made mistakes along the way, but they haven't been for any self-serving purpose. I can assure you that our mistakes have been made, if to the extent that they have been, and to the extent that they had an adverse effect on our ongoing areas. We worked hard to fix those. We try to be responsive, both to the vendors who are trying to operate in a well-regulated marketplace to produce safe products for you, the consumers, and we really want the consumers to have input on this. And so this is part of the problem. And I can tell you without equivocation that one of the goals of the Global Kratom Coalition, and it is public, is they want to get rid of me. And they think getting rid of me as the spokesperson for AK, that AK folds and it clears the pathway for them. And I don't think that's a great outcome. And it certainly isn't going to be good for the consumer, given the agenda that is clearly articulated in multiple regulatory proposals being advocated for and by the Global Kratom Coalition. I'm hopeful that we're going to be able to shake hands on a deal and work together going forward. That is for the good of the industry. It is the good for the consumers, and it's good for regulatory policy in the states, rather than have this consistent infighting, which is created by them. We have not started any fight. We've worked to get 13 KCPAs passed, and now they're shooting arrows at us because they want to come in and change them to clean out the marketplace, to eliminate competition. And we don't think that's what legislation should do. It certainly shouldn't pick winners and losers. It shouldn't be to destroy competition or eliminate it. It should be to protect consumers, and that's what we'll stand to as we go forward. I can tell you that it was great today in Colorado to see the advocates that stood up and were able to say what they needed to say to that legislative body. They needed to hear that there were advocates out there who had a positive experience with Kratom, that in some cases Kratom saved their lives, rescued them from obviously serious problems with opioid addictions and other drugs. And that's what Kratom does. And I think that as we go forward, we're going to want to continue to work as best as we can cooperatively. In 2016, when the FDA attempted it, there were a couple of groups that were on the playing field, and we consolidated our efforts. One went away, I wouldn't call it in the most friendly of terms, but they recognized that it didn't make any sense to have this contradictory messaging. And we don't think it makes any sense today. And we really ought to be working hard on all of this to come together, work together, and effectively share experiences and protect consumers. And let's stop this infighting and internecine wars that really don't serve the public at all along the way. The one thing that really is interesting to me is that there are people that can have And I observed it in the hallway in Colorado today, where there was a differing viewpoint about the regulatory policy that would be best for consumers. But there wasn't threats, there wasn't a nasty, name calling. It was a reasonable, spirited discussion. And as a witness of that, I can tell you that that's the right pathway going forward as we work on these things. And I think that where we find areas where we can legitimately disagree, we ought to do that in an appropriate location and venue, not to have these public fights on social media or name calling that goes on or filing lawsuits against each other. That's not happening on our side. And that's really kind of the problem we run into today. And I know, and it's really interesting to hear the reactions from the GKC folks, and they say, "Oh, well, you get on these webinars and you badmouth us." I'm explaining to all of you the circumstances we're fighting for on a daily basis, and I'm being honest about it. But I'm trying to find a pathway that we can move forward as we work to try to protect this marketplace. We've made amazing progress since 2016, and we're now fighting an aggressive offensive strategy as opposed to playing defense. Sometimes we have to play defense, but the majority of our efforts are really positive, forward-thinking, and very effective regulatory schemes that really do protect the marketplace, and that's our goal. So I'm gonna leave it at that. If anyone has any last burning question they want to ask, the Q&A is open, and you certainly can ask that anything that you might have. So I'm going to leave it open for 1 minute here, and see. And while we're doing that, let me say another thing. Uh, the time requirement to meet all of these challenges for all of the states that have outlined overlooks one important thing, and that is that we're fighting battles at the local level too. And I don't want there to be any misimpression that we're ignoring you. I mean, we may not be as active as we hoped we could be in some of these states, but I can tell you that John Shinholzer and Laura Romney are leading the AKA's effort in order to be as available as we can and to provide as much information as we can and be present in as many of these local bands that are going on around the country. We're working hard at this. We're stretched very thin with resources because we don't have a large staff. Our resources are being diverted away to fight things like lawsuits that are being filed against us. Those kind of things are disappointing, but we're not going to stop. We're going to keep fighting. We're going to do our best for you. And when we send out an appeal, we hope you'll respond. And let's set aside all of these side battles that are going on and think about how we can most effectively put out a message to a public policymaker who's going to make a decision about whether kratom is legal or not in their community or in their state, who's going to make a decision about whether or not they're going to restrict access of kratom products to people that legitimately have a right to use for their own health and well-being a product that they're well informed on and is otherwise safe. I think that's an extremely important thing to do. And the time has come to call the FDA out for their attempts to create a utopian nanny state. That's what I referenced in my op-ed at Supply Side Insider. This is what we got to do. We got to stop the FDA being able to dominate using their bully pulpit, the misinformation they circulate. We got to stop this nonsense about kratom being dangerously addictive or deadly, because we believe at the American Kratom Association that every fatality that is attributed to or causality associated with kratom needs to have one thing at the end of the day, and that's the truth. And the truth requires that there be an exhaustive review of any autopsy that just did check the box because kratom was detected, therefore it's kratom. There was a death report that was testified to by a grieving mother about her son, where she pointed out that her son had, and I think it was 179 milligrams of kratom. And she tried to make that case that's all he was doing, that's all he had in the system. And that shows you how little kratom there is that's required to cause a death. That's not a good scientific argument. And without seeing the benefit of that autopsy report and being able to do what the Centers for Disease Control did, which is look at those so-called kratom deaths, and where they found that they were all polydrug use or adulterated products or in the case where they're Kratom only, they examined them with more precise instruments, and they found that for those that had blood samples available, 4 of the 7 Kratom only deaths, that they were polydrug use. The truth should prevail on this, and we're working hard to make sure that we advocate for families to get the truth, and that can only happen if the medical examiners are willing to adopt a standardized post-mortem death investigation protocol. Then we'll know that we're getting to the truth. And you don't have a medical examiner that calls a death Kratom when the only thing that they asked the forensic testing laboratory to test for was metrogeny. And that has happened a lot. And we're proving it. So stand by for more details on that. The Tampa Bay Times article, the Deadly Dose series, it was wrong. And we used their methodology to collect all of the data that they claimed that they had basing their article. And we have now got conclusive data that shows that their evidence and data is just as embarrassing as the FDA's, because it really doesn't meet the standards that they themselves said that they wanted to hold themselves up to. So lots of interesting things going on. We're going to continue this fight, and we thank each one of you for your continued advocacy efforts in spite of all of this confusion, because I think we have one shared goal at the end. And I believe this is true even for these competing groups, and that is that we want Kratom to remain legal. We want consumers to only be exposed to those things that are safe, those products that are safe. So we're going to continue to work hard on that. John asked the question about what's happening on the federal level. We're going to be refiling the Federal Kratom Consumer Protection Act. And I mentioned earlier on this call a more positive view from the Trump administration with respect to Kratom. And we think that offers an opportunity for us to have discussions with federal regulators about how to properly regulate Kratom, and that might take off some of the edge in some of these states that we're working on. But we're going to continue to work on all of that. Some other questions. Lori, is the AK opposed to Kratom vendors selling 7-OH with clear distinction or education, blending it with a safe, full spectrum Kratom product is an anonymously recommended method of use on Reddit? Thank you. Not sure, Laurie, I understand that entire question, but here's what I'll tell you about the AK's position on 7-OH. We don't think that 7-OH products should be called Kratom if they exceed the 2% level, which we know is the highest level that any naturally occurring product with 7-H could occur. Anything above that is synthesized. If a product then goes on the market that is not Kratom and is 7-OH in a synthesized form, has to meet the federal standard without fail of prior to market entry, which we know they violated, having the safety study, and since it's on the market, produce it, that you have sufficient safety studies. We know that those that have presented data admit they don't have it yet, but they're relying solely on market experience. And I've already identified the deficiencies in market experience because adverse event reports are not being attributed to anything but Kratom, and that would include 7-hydroxymetrogene and metrogene pseudodoxil products. I mean, there's lots of things out there that are happening in this very innovative and creative space that are potentially dangerous, and we're against those. And there's nothing that education can clear up on this other than you don't say, take a 7-OH product because it's better than Kratom. And you know what's better about it? It's more addictive and more deadly. That's it. And if you're a drug seeker, maybe that's going to help you, but that's not going to be the pathway. And without good safety data that controls the serving size of a 7-OH product that you can demonstrably prove is safe, then I think you're off the market. Lori, I hope that answered your question. I'm not sure I did that very well, but we're going to continue to fight that battle as well. So with that, we'll conclude with the thanks again of all of you joining us. We're going to continue this fight. We'll hopefully be able to report to you by the end of the week whether we have an agreement and with these other groups. We hope that we do. We hope that it holds. This is almost like what we see internationally when you think you have an agreement, but do you really? And the test will be whether it holds for a period of time that shows that it is effective. And that's our goal. We want to see it happen that way. And that can, of course, benefit all of us as we go forward. So thanks to everyone for being here. As always, you can reach out to us. We ask you to go on to AmericanKratom.org and be alert to and hopefully respond to all of the advocacy messages we send. Sometimes we get our notice a day or two ahead of time, and that's just a natural function of a crazy legislative process. And that means sometimes I got to get on a plane and fly within a day or two to get somewhere, and it's very disruptive to schedules, and it leaves me not as in a communication mode as I would like. So this is great to have this occasion to answer your questions and to hear your opinions and responses. So appreciate all of you. Thanks so much, and have certainly have the great rest of the week, and we'll hopefully be talking to you soon.